Hi, my name is Kristin Wilkinson. I'm a local real estate advisor here in Southwest Florida, talking to you today about property taxes in the state of Florida. Now, I have to have a disclaimer that I am not a tax attorney, so my information that I'm giving is generalized. Always consult with your tax attorney before making some sort of a tax decision. 950 people are moving to Florida per day. Maybe they're moving for the weather, maybe they're moving for the lack of restrictions, maybe they're moving for the beaches. If they are moving here or you already live here, one question that a lot of people have in common is, what are my property taxes going to be like in Florida? Maybe you found yourself asking, are my Florida property taxes based on my purchase price? Are Florida property taxes paid once a year? Are property taxes high in Florida? Is Florida a good state to live in for property taxes? How much are property taxes in Florida? Why are property taxes so low in Florida? What is Florida property tax portability? When are Florida property taxes due? Are Florida property taxes paid in arrears? Are Florida property taxes higher or lower than California, Illinois, Connecticut, Rhode Island, Massachusetts, New York, New Jersey? If you found yourself asking any of those questions, this video is for you. We're going to cover all of that in here. So whether you're a current property owner here and you've taken advantage of the Homestead tax exemption and Save Our Homes and you're considering moving up or moving down, this video is for you. Or maybe you recently purchased new construction and you are wondering what your taxes are going to be like. Or maybe you're just curious and you're looking to purchase property here. Let's get into it. You probably have already heard that Florida has one of the best primary residence tax laws in the country, especially our portability. There are 3 distinct categories as provided in the state's constitution. Those are the ad valorem taxation exemption, which is the homestead tax, 2, protection against any forced sale by outside creditors, and 3, restrictions on title transfer. Each category has its own distinct standards and case law. Standard for one category may or may not apply to another. So again, another reason why it's important to consult a tax attorney. So the first question you've probably asked yourself or are asking yourself is, do I qualify and how do I qualify? So in order to qualify for the homestead tax exemption, you must have closed on your property the year prior, are living in that property that you closed on, that you have title in on January 1st, and have filed the appropriate paperwork with the appraiser's office by March 1st. Important note is that you really only have to apply for the homestead the first year that you live there. This is not an annual application or notification to the appraiser's office. Your intent must be that this is going to be your primary residence. And know that there is only one homestead per family unit, meaning that if you're a married couple and you're living together as a family unit, one party or one spouse cannot go buy a property in their own name and homestead that property and then have the secondary spouse do the same. There's only one homestead per family unit in the state or in any other state. Citizenship is not required, but proof of permanent legal U.S. residence is by the owner or his dependents, i.e. a green card is sufficient. And proof that you live there. Best rule of thumb is to make sure that you go to the DMV, get your license turned over to whatever property address is local and that you're applying for the homestead for. This is going to help you out. So before I jump into what type of property qualifies for the homestead tax exemption, although I'm not going to get into federal tax, I do want to point out that there is a homestead tax benefit available to homeowners in all states. You may want to look up Internal Revenue Code 121. I will not interpret that. I will allow you to look that up yourself. Further, there's no estate tax on a Florida homestead because Florida has no estate tax. Okay, so taxation. What kind of property qualifies? A single family home qualifies. In Florida, we have all kinds of fun names for condos like casitas, villas, coach homes, carriage homes. You've probably heard it. All of those qualify. A co-op qualifies, and a mobile or modular home as long as it owns the land underneath it also qualifies. Let's talk about the deduction amount. The short of it is $50,000 off of the assessed value of the property. The assessed value of the property is determined by the property appraiser. There's some additional benefits to qualified individuals as well. I'm going to list those now. Seniors over 65 with limited income. This is a local option and varies by the locality. Veterans and first responders who are disabled. Surviving spouses of veterans and first responders who died in the line of duty, other disabled, widowed, and blind, just to name a few. When you go to the property appraiser's office and you file that paperwork before March 1st, as long as you lived in the house, closed the year before, and were a permanent resident of that home on January 1st, you should also be applying for the Save Our Homes tax break. Here's the background on Save Our Homes. The real estate market has been long characterized by booms and busts, but historically the appreciation created in the booms have vastly outweighed the declines suffered in the busts. Real estate taxes are ad valorem, or based upon property value, and as a result, many homeowners, particularly elderly residents who purchased a home years ago at a much lower price than its current value, were faced with ever-increasing tax bills. To combat this unfairness, in 1994, Florida voters approved the Save Our Homes benefit. If you're familiar with Collier County and Naples, imagine somebody who purchased a property back in the 70s in Pine Ridge Estates. They probably only paid between $60,000 and $70,000 for that property. But today, if we go in that same neighborhood, the lowest property in there for sale is going to be at least $1 million. That's where Save Our Homes comes into effect. Save Our Homes says that the assessed value of a property cannot increase more than 3% of the assessed value per year, or the CPI, which is the Consumer Price Index, whichever is lower. For years, the CPI has been under 3%, but with this last year, with inflation, it may be higher than that, and if it is, the lower number will be in effect. So those property values will not increase by over 3%. Over the years, Save Our Homes can become a big accumulated benefit because the assessed value stays artificially low. This artificially low assessed value is called the cap assessed value. If you're looking to sell your property, this is something that we'll want to talk about because, of course, each value with the Save Our Homes tax benefit, if you did in fact apply for it, would be different depending on the property. So we can calculate those and see how we can make that portable and move that over to a new property, whether you're moving up or moving down. So let's talk about portability. So again, while Save Our Homes helps the people who want to stay in their current property, what happens if they want to move? In the past, the homesteader would lose their Save Our Homes benefit. And this is because all property in Florida is reassessed for taxation purposes upon its sale and purchase. In 2008, Florida voters approved portability, which allows a homeowner to transfer the accumulated Save Our Homes benefit from their old homestead to a new homestead. That is one of the reasons why Florida is such a great state for property taxes. Again, there is a way to calculate this, but probably better to do it with a professional. That way we can walk you through the process and the numbers come out right. A couple of rules on portability. There, of course, is a proper set of paperwork to use the portability and time rules. So Florida homesteads only must establish the new homestead within 3 years of January 1st of the year that you abandoned the old homestead. So if the old homestead is in March 2020, you must establish the new homestead on or before January 1st, 2023. Put another way, you can only go 2 tax years without having a homestead exemption. Put yet another way, you must have a homestead exemption on the old homestead in at least one of the last 3 tax years. A tax year here is defined by January 1st to December 31st. So location rules, both homesteads, the old one and the new one, must both be in the state of Florida. Yes, they can be in different counties. You don't have to sell the abandoned homestead. You can keep that home and rent it out and transfer the homestead to a new property. We're going to go over just a few caveats with portability. One, the old and new homesteads must be in the state of Florida. Although the most common way to use the portability is to sell the old homestead and move into a new one, you can just drop the homestead on the old house, rent it out, and transfer that homestead to the new property. You can port your full homestead if you are upsizing your property, and a percentage of it if you're downsizing. $500,000 is the maximum benefit that you can port, and there's a divorce rule, but I'm not going to get into that. One of the other great benefits about taxes and property taxes in the state of Florida is asset protection. Asset protection is liberally construed in favor of the homeowner, meaning that the homestead is protected from outside creditors up to a half acre inside the municipality, which is the city or the town, and up to 160 continuous acres outside of a municipality, and unlimited value in all instances. It is, however, important to know that you're not going to get out of paying your property taxes. Any debt which the owner has voluntarily pledged the home up as collateral, like a mortgage, it does not protect you from condo or HOA liens, and it does not protect you from mechanics liens arising by statute, or of course, federal taxes. In 2001, the Florida Supreme Court ruled that the mansion loophole is legal. Do you remember somebody named O.J. Simpson? Do you remember that he lived in California, and when he was sued, he sold that California property, bought a property in Florida, and dumped all of his money into that? That is the mansion loophole. It's worth noting that there is no length of residency required on that mansion loophole. Now, this is not the case, and there really is no protection if you are found to have defrauded someone. It's worth noting that asset protection begins as soon as you make that property your permanent residence. There is no filing required like in the homestead tax break. The last point I'm going to make on asset protection is something that is called beyond the grave. So once you die, outside creditors' liens and debts still do not attach to your homestead. This means that your heirs take your homestead free of creditor claims. Your homestead is not part of the estate that is subject to creditor claims. Nearly all of the rest of your estate is subject to those claims. But again, you want to make sure that you're consulting your tax attorney or estate planner about these sorts of things before you make decisions. And the last main category of benefit for property taxes in the state of Florida is restraints on transferring title and devise. And just a couple of notes on this one. If you're married, and this includes same-sex married couples, or as joint tenants with rights of survivorship, then the survivor takes all, and restraints on devise do not apply. If a homestead is owned in an individual's name or tenants in common, then there is a different paradigm that should probably be discussed one-on-one. If a homestead is owned in one spouse's name, then the other spouse must join in any transfer of title or mortgaging on the homestead. Even if you're legally separated, you're either married or you're not. This means that if you own a property with a spouse, same-sex couple or not, and you're married and you're homesteaded, both spouses have to sign listing agreements, both spouses have to sign documentation. So to answer your questions, yes, our tax laws are better than California's. Yes, they're better than Connecticut, Rhode Island, Massachusetts, almost any other state, and probably every other state, in my opinion. Taxes in Florida are low. There is no state income tax. Taxes are paid in arrears, and they're paid in the month of November. In order to apply for homestead tax exemption, the proper paperwork must be filed with your county tax assessor's office by March 1st. You'll want to get with your realtor or consult a realtor to help you through that process. Again, my name is Kristin Wilkinson. I'm a local real estate advisor here. If you have any questions about what I just talked about, if you have the Save Our Homes benefit and you're considering selling and porting that over to another property and want to run through some calculations, please feel free to reach out to me. You can do so by calling me, texting me, or booking a time slot on my calendar. And as always, anytime you're dealing with tax law, you want to consult a tax attorney before you start signing paperwork, making decisions. I cannot recommend that enough. I hope that you enjoyed this video. We'll see you next time.